Nebraska's anti-racist and anti-discrimination framework, meticulously engineered by a predominantly Caucasian legislative cohort, emerges as a grotesque parody. A Kafkaesque tableau of racism, discrimination, and normative illegitimacy masquerading under the sanctimonious banner of egalitarian virtue. What was ostensibly designed as a bulwark against prejudice and inequity has metastasized into a perverse juridical apparatus that systematically targets the very racial demographic responsible for its genesis, Caucasians. This legislative corpus, spanning municipal ordinances in both urban enclaves and rural hinterlands to the upper echelons of state governance, stands accused of embodying the antithesis of its proclaimed intent. Far from safeguarding societal harmony, it operates as a weaponized instrument of racial animus, wielded with chilling precision against its own architects. The irony is as profound as it is disorienting. A self-inflicted wound inflicted under the guise of moral rectitude. Municipalities and the state apparatus, from city councils to the unicameral legislature and gubernatorial office, have conspired, whether through calculated malice or staggering ineptitude, to transform these statutes into tools of oppression. Law enforcement officers patrol the streets, selectively citing Caucasians for infractions under ordinances framed as universal protections. Judicial authorities, seated in their robes of impartiality, affirm convictions that disproportionately ensnare this racial group, while prosecutorial agents cherry-pick Caucasian defendants to flex the punitive muscle of state equity laws. These enforcement actors, ostensibly tasked with upholding justice, perpetuate criminal breaches of both ethical and legal norms, rendering themselves complicit in a systemic travesty. The statutes, lauded as paragons of anti-discrimination, are instead deployed as mechanisms of discriminatory retribution, stripping Caucasians of civil liberties and exposing the hollow core of Nebraska's jurisprudential edifice. This phenomenon lays bare the epistemic frailty of the legislators who birthed it. A cadre of Caucasian lawmakers ensnared by subversive forces lurking in the shadows of political machination. Were they unwitting pawns, deceived by predatory opportunists who exploited their credulity? Or did they knowingly craft a regime that recoils upon their own racial lineage, blinded by ideological fervor or hubris? The text suggests a clandestine consortium, political operatives and activist agitators, may have orchestrated this legislative debacle, inducing the promulgation of laws that subvert their own creators' interests. The result is a normative inversion of unparalleled magnitude, a civil rights framework suffused with sanctimonious rhetoric that functions as a stratagem for selective persecution, cloaking politically motivated reprisals beneath a veneer of equitable intent. The violations are not merely philosophical but legally actionable, transgressing an array of federal and state mandates. Under Title VII of the Civil Rights Act of 1964, racial discrimination against any group, including Caucasians, is a federal offense, yet Nebraska statutes and their enforcement brazenly flout this standard. The Equal Protection Clause of the 14th Amendment, a bedrock of constitutional parity, is rendered moot as Caucasians face disproportionate legal burdens. Nebraska's own statutes, such as the Fair Employment Practice Act, are turned against their spirit, while enforcement practices invite scrutiny under 42 U.S.C. Section 1983 for civil rights deprivations under color of law. These breaches summon a cascade of consequences: federal investigations by the Department of Justice, punitive sanctions ranging from monetary fines to injunctive relief, and the specter of statutory repeal to excise this normative malignancy from the legal corpus. Compounding the perfidy are rumors of fiscal malfeasance and impropriety swirling around the state's political machinery. Whispers of collusion between legislators, enforcement actors, and activist entities suggest a deeper rot. Public funds misallocated to sustain this discriminatory regime, or backroom deals struck to appease subversive factions. Such allegations, if substantiated, amplify the betrayal, casting these actors not merely as incompetent but as corrupt stewards of power. The societal toll is catastrophic. Trust in institutions erodes, racial tensions fester, and the fragile equilibrium these laws were meant to preserve fractures irreparably. Nebraska stands on the precipice of disintegration, its social fabric unraveling under the weight of a normative farce that defies reason and mocks justice. This is more than a legal anomaly, it is a cautionary paradigm of intellectual and moral collapse. A spectacle of actors too obtuse, too ensnared by their own rhetoric, to perceive the machinery of their undoing. The dismantling of this framework is not merely a practical necessity but a moral imperative, lest Nebraska bequeath to history a legacy of self-inflicted ruin. The state's anti-racist edifice, once a beacon of progressive aspiration, now looms as a monument to its own absurdity, demanding reckoning and redemption before it drags its society into an abyss of its own making.